And we have breaking news tonight. The New York Times reporting federal prosecutors overseeing the probe into former President Trump's handling of classified documents are seeking to compel one of the former president's attorneys to answer questions before a grand jury. The Times reporting the prosecutors are seeking the approval of a federal judge to invoke the crime fraud exception, which would allow them to work around attorney-client privilege. Professor Emeritus at Harvard Law School and author of the book, The Price of Principle, Why Integrity is Worth the Consequences, Alan Dershowitz joins me. Good evening, Professor, and I don't know about you, but it sounds like we're on that slippery slope when they start putting defendants, lawyers before, or at least someone who might be a defendant, lawyer before a grand jury. Things are sliding in a particular direction, the attorney-client privilege.
There's a bigger issue there as well. The motion to compel the lawyer to testify was sealed, under seal, and yet the New York Times published it. Good for the New York Times, but bad for the person who leaked it. And this judge, who has always ruled against Trump, has to now convene a hearing and find out who leaked this sealed material. When there are lawyer-client privilege issues, they have to be kept sacrosanct. And the idea that somebody, whether it be on the prosecution team or somebody else, leaked it to the New York Times is absolutely essential and should be investigated. Because I agree with you, once you start breaking lawyer-client privileges, and there's a group out there called Project 65, whose goal it is to try to disbar and go after lawyers who in any way defended Trump. They are going after me, even though I defended him, 3 years ago. And there is a real attack on lawyers today. And
where are the feckless American Bar Association on this? Are these lawyers groups? I mean, it's just not. Look, a lawyer can't commit a crime with a client. That's when the very narrow exception when there's no attorney-client privilege. That's what they call it, crime fraud. But now what's happening is that you see so often where prosecutors are trying to break that bond, even though the Constitution, speaks directly to attorney-client and how important it is.
No, I completely agree with you. And the burden should be very heavy on prosecutors to demonstrate that the client tried to use the lawyer in a criminal fashion and that the lawyer essentially cooperated. It's a very serious matter to accuse a lawyer of something that would cause the lawyer-client privilege to be broken. And it shouldn't be approached in a very, haphazard way, the way it often is approached. So I would hope we would get to the bottom of it.
I think people approach it about whether you like Trump or don't like Trump, not whether you think that this is an important issue of constitutional magnitude and what it does to our system. I think this will be decided solely, among the masses, among people, among journalists and the media. Do you like Trump or not? Not whether or not something is trying to erode the attorney-client privilege.
In America today, we have two legal systems. One, a regular legal system, and the other one that involves Trump. And when it involves Trump, the rules just don't apply. I have a book coming out called Get Trump, which systematically evaluates how the law has been distorted in an effort to prevent Trump from running for re-election. Now, look, I want him to run for re-election so I can vote against him for the third time, as I did twice before. But I don't want to see civil liberties destroyed in the name of getting Trump. And we're seeing judges complicit in that, bar associations complicit in that, people who ought to know better, civil libertarians, the American Civil Liberties Union, all complicit in that. And it can do more harm to the Constitution than anything since McCarthyism.
All right, let me go to the speech or debate clause. Former Vice President Pence says that he's going to fight the subpoena to testify before the grand jury, and he's citing the Constitution's speech or debate clause. Is he going to win or not on that, or should he?
I don't think so. The speech and debate clause has two provisions. One, you can't be arrested on the way to the Senate or in the Senate, and the other one that says any speech or debate in either house. He's not being asked about a speech or a debate. He did make a speech when he refused to accept President Trump's request to not count the votes. But he's being asked about what happened in the White House, and therefore executive privilege is more appropriate. But remember, he doesn't get executive privilege if the president doesn't want him to. So he's used this speech and debate provision. It's clever and it's creative, but in the end, I don't think it will work. At least it doesn't satisfy the text of the Constitution.
And it also, isn't it to be sort of to protection of something in your legislative duties? And I know that he was president of the Senate, but to say that he's part of the legislative duties in terms of his conversations at the White House doesn't seem to me to fall within the purview of the speech or debate clause.
Yeah, but he does have a legislative duty. He can break a tie, and he did break a tie on numerous occasions, and he can't be questioned about that. But if he is questioned about what advice he gave to the president about January 6th, he can be questioned about that under speech and debate, but probably not under executive privilege.
Professor Alan Dershowitz, thank you.